Hello, folks. Thank you for tuning in. This is California estate planning attorney Ryan Casson here on my YouTube channel, Estate of Affairs. So I'd like to talk to you for a few minutes about a very critical, a very important California estate planning concept, which is the California Medi-Cal Asset Protection Trust. The Medi-Cal Asset Protection Trust, or MAPT. MAPT. The MAPT is an irrevocable trust that you would create if you are trying to maximize and maintain your potential future Medi-Cal long-term care benefits eligibility. I know these are a lot of words: long-term care, benefits, Medi-Cal Asset Protection Trust. So for many of us, at some point in our lives or the life of a family member, we require some additional care that just cannot be accomplished and maintained at home or through a trusted family member or friend, and we need some significant care. So that's what we're talking about with Medi-Cal long-term care benefits. And if you're watching this video, perhaps you've heard of this. So here in California, in some circumstances, certain types of Medi-Cal long-term care benefits can be provided at home. So those are more community type benefits, or community Medi-Cal, in-home supportive services, something like that, where a caregiver comes to provide, a certain level of care at home. And that can be challenging in and of itself, depending on your county and where you reside in California. There are different programs. They can become incredibly complex, awfully quickly. So the complexity and nuances of these community benefits type of Medi-Cal can depend on your county, believe it or not. And there are often wait lists. So that is a whole nother lecture, perhaps more than one. So nevertheless, we have that traditional full on, typical nursing home level type of benefits as well. So Medi-Cal can potentially provide either or. So we all want to stay at home as long as we can, of course, but sometimes it's just that time comes when you and or your loved ones decide to seek Medi-Cal nursing home benefits. So in either case, we're talking about a financial eligibility component. There's, a medical component too, of course, a physical ailment or Parkinson's, something like that, or a cognitive ailment such as Alzheimer's or dementia. So we are honing in on the financial criteria. So like many states, California does have an asset cap, an asset limit, or yet again, an asset test. So that is where your countable assets or countable resources are tested. They matter. So there is such a thing as a countable asset, and you guessed it, a non-countable asset. So what assets are countable and what assets are not countable? And what is the limit? Well, in many states, it's a mere $2,000. Here in California, we have a grand old asset limit of $130,000 as of the date of this video here in April of 2026. Years ago, California's asset limit actually was $2,000, but then we increased it to $130,000. So assuming you are otherwise eligible for Medi-Cal, theoretically, your countable assets would need to be below $130,000 as a single person. So the primary residence, fortunately, does not count toward. It does not count toward or against that $130,000 asset cap. Again, your primary residence is what we call an exempt asset, which is wonderful news. Perhaps you have $10,000 in a checking account and $50,000 in a savings account. That's a total of $60,000 in countable assets, which is below the $130,000 asset limit currently. Well, if your home has no mortgage, your primary residence, let's say theoretically, does not have a mortgage, and the fair market value is $600,000. That $600,000 primary residence does not render you ineligible. Assuming you are otherwise eligible, you can still have that $600,000 home. And if that home is in your revocable living trust, which is very common in California, Medi-Cal cannot recoup or seek reimbursement for whatever benefits they pay you if you do eventually receive Medi-Cal long-term care benefits. Medi-Cal could not seek reimbursement from your living trust when you pass away. Again, that can get into the weeds in and of itself, and that can be another presentation here. But Medi-Cal can only recover through probate. So that's a step in the right direction, right? Putting your primary residence in your revocable living trust is incredibly common. You pass away, the trust becomes irrevocable. If you're a single person, and if you're married, you're usually going to have a joint revocable living trust, but let's keep this simple for purposes of illustration. Let's say you are a single person, you pass away, your home is in your revocable living trust, it becomes irrevocable when you pass away, and let's say Medi-Cal paid out $200,000 for your nursing home care over the course of a few years. They do not get a dime from your trust. Period. End of story. That's a great result. But what if there was some circumstance where you needed some liquidity from your home, or maybe you wanted to downsize, or you wanted to sell your home and move in with one of your adult children? Here's the problem. The sale proceeds of your home, if you sell your home, if you sell your primary residence, that otherwise exempt asset, the otherwise exempt home, results in non-exempt cash, and that's a problem. If you are a power of attorney, for instance, and you do that without proper, appropriate a counsel from an experienced California estate planning and elder law attorney, you could expose yourself to some legal liability. If you were acting as a fiduciary and you don't seek out appropriate counsel, that can be a very challenging situation, not just for your loved one who then is in the horrible situation of not being otherwise eligible for Medi-Cal because you sold their home, and rendering the sale proceeds countable, and now there's $1 million or even $400,000 sitting in your loved one's or your own checking account. That is countable, and that is well above the $130,000 asset limit. Yikes. Yeah. So there is a way around that. There is a way with advanced planning, which is not as complicated as you might think, to prevent that nightmare situation, and to rather instead allow for and create a little bit of flexibility if that home needed to be sold. So the way to do that is to utilize a Medi-Cal Asset Protection Trust, a Medi-Cal Asset Protection Trust, or MAPT, the MAPT. Transferring the primary residence to the Medi-Cal Asset Protection Trust, number one, does not result in property tax reassessment. So I'm going to give you three off the top of my head, three very nice benefits to doing this, or 3 factors that show there's minimal downside in many, many instances when this type of planning is undertaken. So again, number 1, there's no property tax reassessment as long as in this irrevocable MAPT, Medi-Cal Asset Protection Trust, as long as you retain what's called a right of occupancy. A right of occupancy, as that term implies, that affords you a sole and exclusive lifetime right to reside and occupy in that home, in your primary residence. So as long as the Medi-Cal Asset Protection Trust includes the sole and exclusive right for you to reside and occupy that primary residence for your life, as long as that residence exists and it's in the trust, there is no property tax reassessment because the California Board of Equalization, or BOE, which comes out with and issues our complex property tax regulations here in California. There is a clear BOE, or Board of Equalization, rule that essentially confirms and affirms transferring your primary residence into a trust where you, as the trust maker, you retain that right of occupancy. There's no reassessment. So we have support for that. So that's great news. A little bit of a trade-off, though, is you do, in that situation, you do retain and continue to be obligated to pay the costs of the home. So the mortgage, if there's a mortgage, you personally are responsible for continuing to pay the mortgage. The property taxes, whatever you were paying, you have to keep paying. The new roof, new water heater, basic repairs, upkeep, insurance. So you do retain the obligation to pay the costs of home ownership. Again, mortgage, property tax, insurance, etc. So you do need to have the cash flow to continue to pay those costs, whatever they may be. But bottom line, this first point is no property tax reassessment when you transfer the primary residence into the properly drafted Medi-Cal Asset Protection Trust that has built into it, if it does, the right of occupancy that allows you to retain the sole and exclusive right to reside in the premises. So number 2, there are some pretty good income tax results. I'm going to use a word that is kind of some legalese, but it is very common in the estate planning world, and that word is a grantor trust. Your irrevocable Medi-Cal Asset Protection Trust is what we call a grantor trust. Well, what does that mean? The simple definition of the grantor trust concept is that for income tax purposes, we see through the trust. So the income tax responsibility, whatever that may be, still rests with you as the trust maker. So the home is in the trust, but for income tax purposes, the IRS is going to say you, the trust maker, remain responsible for paying whatever the income tax is. So the income tax attributes after putting the home in the MAPT, it's as though we see through it and the home is still in your own name. So the simple and, the very common issue that we're talking about, or the common situation, is selling the home. And it is tax neutral in that sense. If during your lifetime, the Medi-Cal Asset Protection Trust trustee sells your home from the Medi-Cal Asset Protection Trust for capital gains purposes, it is just as though the home had been in your own name all along. So the sale price minus whatever purchase price that you purchased that home for, and potentially some investments that you put in there, and you and or the MAPT trustee would consult with a CPA, potentially before the sale, just to make sure that you had the appropriate documentation. But at the end of the day, Capital gains is calculated by sale price minus your cost basis. The purchase price, maybe 30 years ago. And again, whatever, generally additions and improvements, the cost of the improvements can kind of bump up your basis. So selling from the irrevocable grantor Medi-Cal Asset Protection Trust is just as though for income tax purposes you were selling in your own name. That's wonderful news, folks. No downside to transferring the primary residence to your Medi-Cal Asset Protection Trust from an income tax perspective. Great. So as well, secondly, another income tax point, which is good news for your beneficiaries. Just as if your beneficiaries were inheriting from your living trust, your revocable living trust, after your passing, it becomes irrevocable and they inherit some type of property from the revocable living trust. They inherit at a stepped up basis from the MAPT as well. So your Medi-Cal Asset Protection Trust beneficiaries, maybe it's your kids, just as if they are beneficiaries of your traditional plain vanilla revocable living trust. They inherit the primary residence from the Medi-Cal Asset Protection Trust with a basis which is the fair market value on the date of your passing. So there would be an appraiser that would come out and do a formal, a proper appraisal report as of the date of your passing. So the date of death fair market value would be the value that your MAPT beneficiaries inherit the property, not your basis. It's not a carryover basis. So the beneficiaries would not have capital gains tax calculated if they sold it based on what you bought your home for, let's say 30 years ago or 20 years ago. No. It would be the sale price minus the inherited fair market value on the date of your passing. So potentially minimal or no capital gains tax for your beneficiaries, especially if they sell fairly quickly after your passing, and that potentially could be talked about in advance. And what would your MAPT beneficiaries potentially consider doing? It is worth considering in advance if they have families that live in another region of California, or they live out of state and they don't think they're going to be residing in the home. Maybe they would talk to you about that in advance, and you'd kind of understand that you're going to reside there as long as you reside there, and if and when something happened to you and you were to pass away, your beneficiaries would potentially work with the real estate agent and a CPA and sell your home, and they would be able to enjoy potentially minimal, if not prevent any capital gains taxes, because under the MAPT they would receive a basis adjustment. That's the technical income tax term, a basis adjustment. Oftentimes, as long as the property value increases, they would have a step up in basis. So again, that is good news as well, just as there's no property tax reassessment if that MAPT is properly drafted. And secondly, there is a capital gains tax neutral result for a lifetime sale from the trust and upon your passing by the beneficiaries. That is a wonderful result. So third and finally, we need to talk about the potential transfer penalties that oftentimes happens with gifts prior to seeking Medi-Cal long-term care eligibility. So if you are trying to seek Medi-Cal long-term care eligibility at home and or in a facility such as a nursing home or a long-term care facility, in general, we are not talking right now about assisted living facilities. So we are really honing in on long-term care nursing homes type facilities, or things like that, a skilled nursing facility. So if you give property away or dispose of property for less than fair market value within 30 months, that's 2.5 years. So if you gift property away within 30 months of seeking potential Medi-Cal long-term care eligibility, that can be a problem in many instances. So bottom line, folks, the good news is the transfer of your primary residence, the transfer of your primary residence to the Medi-Cal Asset Protection Trust does not result in a transfer penalty. So let's say you transfer your primary residence. Maybe you are a single homeowner or you are a married couple, and you transfer that home into your Medi-Cal Asset Protection Trust. And lo and behold, unfortunately, there is a stroke or a bad car accident or something happens that simply at the end of the day requires the family to say, this loved one needs full care, long-term care in a skilled nursing style facility or a nursing home, and we're not going to pay out of pocket for whatever reason. And that is a very sensitive, personal family decision, of course. Again, we could talk about that in another video, but some families might be comfortable spending every dime for the best facility possible, and I respect that. Many of us estate planning practitioners, estate planners, and elder law attorneys, we understand, of course, the sensitive nature of that decision. When does this loved one need to be placed in a nursing home, or how long can we prevent that, or how much money should we spend? That is a very delicate and a very sensitive family conversation, and hopefully you can talk about that as a family with your loved ones in advance of that potential future crisis, so you have your T's crossed and your I's dotted to avoid this complicated conversation and potential disqualification, if it wasn't done right. Again, if you or your family member somehow sold the house outside of the trust, and as I said, the proceeds would render you ineligible, until you're below $130,000. So you want to prevent that, and you want to have that tough conversation about what does long-term care look like for you and your family early, before that crisis happens. So nevertheless, this can be, a very challenging time, even talking about this in advance. So full circle, we want to maintain that potential future eligibility by transferring the home into the trust, earlier, and there's no penalizing transfer. So that creates some flexibility for you and your loved ones in that Medi-Cal Asset Protection Trust trustee to kind of reassess the circumstances if you become incapacitated or you're physically unable to continue to reside at home, either alone or with some type of supportive care. Once the home is in the Medi-Cal Asset Protection Trust, as I said, it can be sold from the trust. The sales proceeds are paid directly to the trust, and that Medi-Cal Asset Protection Trust trustee will have that discretion and flexibility to think about, what to do. And again, whether to sell in the first place inside the trust. So, your adult children and or your spouse, as the case may be, once the home is in the trust, that will give some post-incapacity flexibility to reassess and re-look and reanalyze what that long-term care picture might look like. Maybe some of the proceeds from the sale, if it is sold inside the trust, maybe some of the proceeds inside the trust would be used to private pay at first, and you're going to have that candid conversation with the medical team and with your family to potentially decide to private pay for some really nice care, from the trust. for a period of time before applying for Medi-Cal. Or perhaps you and or your family, you're on the same page, and you, for whatever reason, and it's a very personal conversation, again, you've decided to try to maintain the funds, the protected, the exempt property in the Medi-Cal Asset Protection Trust, and you've decided just to, say, put me on Medi-Cal. Again, just to be direct, perhaps, some individuals might make that decision. Again, not to be redundant, but that conversation is very difficult sometimes, and it's a very personal conversation that I think you should have, early, while you still can, with your spouse and with the folks that are important to you. So, and what do they think that the lifestyle for you, and then their family upon your passing, what do you want that to look like? Again, that long-term care out of pocket, can be very, very expensive, especially if the prognosis is such that it might be, several years or more in a nursing style facility. I don't know, $10,000 or more per month. That can really eat into and deplete some sales proceeds that at first blush seem significant. Over time, those are going to dwindle. So again, I don't mean to be redundant. That is a very sensitive and very unique and circumstantial conversation you have to have with your loved ones, with the people that you care about. But bottom line, full circle, transferring the primary residence, your California home, into the Medi-Cal Asset Protection Trust first, while it is still in your name. You haven't sold it. You put it in the trust. That, bottom line, affords your loved ones and you flexibility to revisit this in the future and to sell from the trust in the future. Again, to enjoy the same property tax basis, to achieve, for income tax and capital gains purposes, an otherwise tax neutral result, as if for income tax purposes you still own the house in your name. That's a second fantastic result. And 3, no transfer penalty. No period of ineligibility from transferring the primary residence into the Medi-Cal Asset Protection Trust. So other than elephant in the room, as they say, other than the out-of-pocket cost to setting this up with the estate planning or elder law attorney now, other than the cost of setting up the trust, what are the downsides? That's the question. That's the question. I am not going to say there are no downsides or across the board there's zero downsides for anybody. I can't be that bold, unfortunately, but in general, it very well may make sense to have this consultation with the California estate planning or elder law attorney now, while you still have capacity and while the home has not been sold, outside of the trust. Because again, once you have those proceeds, the home is no longer exempt. And again, as I've said several times, I don't mean to be redundant, but this is critical. I cannot stress this enough. It is only the primary residence that is exempt. Once you sell it, that exemption is not transferred over. It is not tacked on to the proceeds to protect the proceeds. Every dollar above the $130,000 asset limit is exposed. So if you want to maintain that future flexibility to reassess things and address the specifics of the long-term care picture and who's paying, are we going on Medi-Cal, where does mom or dad or the family member need to be, and what's the most appropriate long-term care picture, you're going to maximize the flexibility and the potential to sell the home from the trust once it is in the Medi-Cal Asset Protection Trust. And of course, if the home is already in a revocable living trust, in general, we could still take it out of the trust and put it in irrevocable Medi-Cal Asset Protection Trust to achieve the objectives that we've been talking about in this video. So that revocable living trust, if your home or your loved one's home is already in the revocable living trust, of course, your estate planning and or elder law attorney would need to, hopefully request and review that revocable living trust before doing any irrevocable planning work, such as the Medi-Cal Asset Protection Trust. But again, I'm just off the top of my head here, I'm thinking you might be wondering, well, Ryan, well, I and my spouse or my parents, they already, 10 years ago, 20 years ago, they put their home in a revocable living trust. Can we still do this? Well, oftentimes, yes. Sometimes we have some complicated wrinkles if one spouse passed away and part of the revocable living trust became irrevocable, but that really gets into the weeds. So again, that trust would need to be analyzed and reviewed as part of the Medi-Cal eligibility project consultation. So again, you can rewatch this video, go backwards, and if there was a section that you want to re-listen to, I encourage you to do so. Of course, you can reach out to me, and again, please don't make any transfers at all, folks, without first consulting with an experienced California estate planning or elder law attorney, even if you think you know what you're doing, and especially if you are a fiduciary, it is well worth the cost of retaining a California estate planning or elder law attorney for some counseling before transferring assets, especially if Medi-Cal eligibility is on the radar, and sometimes it becomes on the radar in a crisis, even if you never thought it was going to be, such as a younger person having a stroke, or a significant heart attack, or early dementia, or a traumatic brain injury. Things happen. So maintaining potential future Medi-Cal long-term care eligibility via a Medi-Cal Asset Protection Trust, oftentimes can be explored before that crisis happens. So again, I am going to stop talking. It was a little bit of a longer video than I had anticipated, but I hope this was helpful. I tried to break this down into some, key bottom line concepts with the property tax results, and how that's a very nice non-reassessment result. The capital gains tax result, where the lifetime sale from the trust is just as though it was in your name, and then your beneficiaries still receive a stepped up basis for capital gains purposes. And then third and finally, the penalty concept in gifting property away to a family member or a trust or otherwise, specifically speaking with this nuance with the primary residence being transferred to the irrevocable Medi-Cal Asset Protection Trust, as that house is that the primary residence is a non-countable asset, that achieves the beautiful result of preventing a transfer penalty. So perhaps now is the time to get this done. That may be what you're thinking, or you're just looking for a consult to think about this for the future. Either way, I'd be happy to talk to you about that. Again, California estate planning attorney Ryan Casson here from my office in Ventura County, signing off. Thank you so much for watching this video. Goodbye.